Good evening and welcome to another People for Effective Government online event. My name is Eric Coltrane, current president of PEG. Chris Venn, another board member, will also be assisting this evening. We'll be facilitating the discussion tonight and taking your questions as well. PEG is a nonprofit, Spokane-based nonpartisan coalition. Our mission is to support bipartisan approaches to governing, which are fiscally responsible, ensure an adequate social safety net, and promote a civil society. We've been holding in-person forums and online events for over 3 years now. For those who are new to our organization and events, we look forward to having you with us in the future. We are committed to changing the current political climate in which our two major parties have been increasingly polarized. We're working to encourage sincere and civil debate about the challenges that our nation faces and about effective solutions to those challenges by providing speakers and information and perspectives on a variety of relevant topics. We're a small grassroots organization working with very shallow pockets. If you're finding these events helpful as you think about issues in government at the local, state, and federal level, please consider joining as a member or making a donation to PEG. We are a nonprofit relying on membership dues and donations to cover our costs. If you're interested in learning more about PEG and possibly about becoming a member, please visit our website, www.pegnow.org. As a reminder, the views presented by all of our guest speakers are their own. As a 501c3 nonprofit, PEG neither participates in political campaigns on behalf of or in opposition to any candidate for public office, nor engages in political activity of any kind. Our audience is welcome to submit questions, encouraged to submit questions. Our speakers will answer as many questions as possible before we end the forum around 8:30 p.m. Please be brief, keeping your questions to only 2 or 3 sentences long. You can ask several questions, but please submit only one question at a time. And please submit them via the Q&A feature. The event is being recorded and will be posted on our website, www.pegnow.org, within a couple of weeks. Our topic tonight is family law, and our speaker is former appellate judge Kenneth Cotto. Kenneth Cotto was a Spokane County Superior Court judge and attained Washington Court of Appeals commissioner and judge. He obtained a BA and JD at the University of Washington. Judge Cotto was an associate and principal at the Huppen Ewing Law Firm in Spokane for 13 years before going on the bench. After 19 years in the judiciary, he returned to private practice as a mediator, arbitrator, and appellate attorney. Welcome, Judge Cotto. And I have to say, we've been having issues with his video today. Normally we have our speakers with video, but we've had some weird things with Zoom tonight. So he may we may just hear his audio for most of the forum tonight. I want to first ask Judge Cotto, thanks for being here.
I'll put on my video, see if it works. Now you can see who I am before it starts messing up.
Let's see if it does that.
Yeah, there it goes.
It's doing it again.
I'm off.
We've never had this particular problem. We've had problems with Zoom, but we've never had this particular problem. So we don't know what's going on, but at least we can hear Judge Cotto. First of all, welcome, Judge Cotto. And how would you like me to refer to you today?
Ken.
Judge, the Honorable, what do you want?
Ken's good.
Ken's good, okay. So why don't we start by having you just explain your career path and your experience, particularly as it relates to family law.
Well, I went through law school at the U. Cost me all of $624 a year for law school, so you know I'm old. Cost $38,000 a year for in-state students there now. But it was time well spent in Seattle. I'm the only one in my law school class to come back to Spokane, and there were probably 35 Spokane natives there. So I was the smart one. I came back. I was hired on at Huppen Ewing. The Huppen is the same as Huppen's Hi-Fi. And Gene Huppen was my senior partner. And I had known Gene since I was a little fellow. because the businessmen used to park in back of my, I'll call it a home, but it was at 333 West Trent Avenue in Spokane. The Spokane Davenport Grand Hotel is 333 West Spokane Falls Boulevard.
I hope you got paid
That-
well for that.
That was my house, but it
Oh,
wasn't a house. We had a hand laundry. But the businessmen used to park in back, and that's where I met Mr. Huppen. If you did not go to the Gonzaga for law school, you basically didn't get any job offers in Spokane. I was lucky enough that Mr. Huppen went to the UW Law School as well, so I got a summer job. I was hired on as a trial attorney. I had my first and last trial in 1976. I was a defendant. We won a counterclaim. I'm 1-0, batting 1,000, and I'm not gonna go back to the trial court. I did not like it. I felt the law was really not even in the forefront or the back. It was who could BS the best in trial court, and I just didn't care for it. So I went into appellate law for my 13 years. Never did any family law. But you learn real fast when I went to the Court of Appeals as a commissioner, because you do all cases. Went back to the trial court, and I saw a lot of family law cases. Family law and criminal law. That gets very depressing. Criminal law because it's criminal law. Family law because it's family law. As a judge on Fridays, you get to do the spillover from the motion docket on family law. So I'd have 40 files stacked in front of me that I'd never seen before. And I would hear 20 cases with those 40 parties, 2 on each side, sometimes more. And I knew that I was going to make at least one side cry every day that I did that.
so just to clarify, not to interrupt your story, so this was in, 20 cases in how many days? 20 motions?
Oh, in about 2 hours. This was Friday. This was just the spillover from what the commissioners were hearing on Friday. And when I was a Superior Court judge there were some judges who refused to do family law cases, even on spillover. That was because it was beneath their dignity to do family law cases. That's not a real good attitude to have.
No.
But I did them. And then I went back to the Court of Appeals as a judge, so I started reviewing family law cases. I left the bench because I didn't figure I was making any difference. I didn't get voted out. I voluntarily left, and it was a pretty good job too. But I left because I couldn't take it anymore. And I went back to being a lawyer. And I do appeals. That means I didn't restrict myself to just civil law, meaning a lot of family law, torts, that's where you get hurt, contracts. I also did criminal law appeals. In fact, I probably sent up about 10 people, either as a Superior Court judge or a Court of Appeals judge, kept them there. And they wanted me to represent them when I went back into private practice. So I'm glad they didn't hold a grudge.
Yeah.
But in any event, I told them, I am the guy who sent you there or kept you there. And they would tell me, oh yeah, I know that. I want you to do it anyway. And I think that probably stemmed a lot from not what I had to do to them, but because I listened to them. And those of you who have been in the court system know that you are very seldom heard, either as a witness or through your lawyer. But eventually, I probably now have half family law appeals and half criminal law appeals. But I do them. I will not go to the trial court and do family law. I don't want to wallow there. I would rather keep it on the cleaner side and do the appeals. So that's pretty much what I do, and there's not too many appeals lawyers here in Spokane.
Thank you for that. And it's good to hear that. I mean, it's sad for you, but it's good to hear that, you recognize, in family law, often you're dealing with kids and things like that, that it impacted you, that you were making one side cry.
It's
And,
sad.
and I want to get to, I have a lot of questions, and I'll tell the audience that, the PEG's done forums on therapeutic drug courts, veterans courts. We've had Tim Fitzgerald here.
Mhm.
We haven't done family law, and it's, in my research, it seems that family law is most likely to impact most of us or somebody we love and care about. But it gets very little attention. There's lots of stereotypes or preconceptions about it. But I've researched this a lot. And so some of my questions are informed by that research, and I don't want them to be leading. I want you to tell me what you think about it. But why I've always been curious, why would an attorney want to get into family law? Some of them wear bulletproof vests. Their offices are locked down. They're dealing with these horrible matters. I mean, I just, as a layperson, cannot understand wanting to spend my life this way. Can you give us some insight into why an attorney would want to get into family law? What the motivations are? And I know you can't, speculate, but what might some of those motivations be?
Let me speculate anyway. I
I
think
like it.
number one is the dollar sign,
Mhm.
because if you do family law and you do it the way that attorneys have been doing it for eons, you earn your money by fighting. But by fighting, you make these picayune motions. You were 15 minutes late for the drop off. I'm going to do a contempt motion. So the contempt motion eventually becomes $6,000 in attorney fees.
Mhm.
How it gets to that is beyond me. But I think that's the major motivation. In fact, just today, I talked to a doctor. She can't be a doctor anymore because she has autoimmune disorder. But in 4 years, her divorce attorney charged her $300,000. $300,000. To me, that's unconscionable. How can you prey on someone who's going through a life-changing scene and make 300,000 bucks and try to take her disability to get paid?
And this is what I saw in my research. I'm a lay person, but and I'll tell the audience, one of the documentaries I watched was on Amazon Prime, and it's called Divorce Corp, as in corporation. This is a multi-billion-dollar industry, and I think, as PEG members, as PEG or people that support our mission, we should figure out if we're doing this as best as we can. And so I want to talk about the cost. You brought it up, and I've read cases, $200, $300, $400, $500,000 divorce cases to end a marriage,
Yep.
just to end a marriage. And in the documentary Divorce Corp, some of the Nordic countries, they may not even necessarily hire an attorney. In fact, most don't, according to this documentary. And I wonder, why are we so different? Do you have any thoughts on that? I mean, why is it necessary? I mean, I've heard of bankruptcies due to divorce. Bankruptcies, people that were formerly, well off or at least okay middle class people forced forced to declare bankruptcy.
That is true. It happens. I have a client who was told by the judge who was hearing her case that by the time I get done with you, you'll be broke. That's not very judgely to say that kind of a thing.
No.
And needless to say, that case is up on appeal. But I'll start with the premise that if you want justice, you don't go to court. I used to tell folks that when I was a judge, and I would get these looks like, how can you say that? You're a judge. Well, yeah, that's how I can say that. I'm a judge. I've seen it. If there's a way to go about doing family law, it would all be through mediation, not arbitration, because then you have a private judge. And yes, you can do arbitrations in marriage cases, but mediation, I think, is the way to go. And that would cut out a lot of the strife. And our system is built on the foundation that family law lawyers make their money hourly. And so it behooves them to fight. It's not good to settle because I'm not going to get the money I feel I deserve to get. And I gave a seminar talk at Gonzaga's Law School, and I suggested to the family law lawyers that perhaps you should think about a flat fee. And I'll bet you 90% of these motions will go away and you'll do what's right. You'll also see collaborative law firms, they advertise that. So what does that mean? I guess that means you're going to collaborate and get this done. Kind of like a mediation. Don't fight about it. Turns out one of those law firms fought everything. That to me is not collaborative law. But we got to get a system away from an adversarial one to really caring about the family and particularly the kids when they're involved.
So much there. I'm going to come back to mediation, but the costs, I want to get to the costs. So, you have families with kids that are financially ruined. Is that, you've seen this, I assume?
Yep. That's when the judge told my client, you're going to be broke by the time I'm done.
Financially ruined. And yet the statutes in Washington state, as far as I can tell, correct me if I'm wrong, the RCWs, talk about the best interests of the kids. How do we reconcile those things? If we're talking about the best interest of the kids and we're going to feign that that's what it's all about, how are we going to say the financial end of that doesn't matter? How can we spend, a fortune? How can we have parents end up in bankruptcy and still pretend that we're doing what the statutes say to do, which is all about the best interest of the kids?
And it isn't in the best interest of the children. It's actually in the best interest of the guardian ad litem. It's in the best interest of psychologists. It's the best interest of the lawyers. And what does best interest of the children mean? There isn't even any definition of it. There are considerations, but if you were really thinking about what the best interests of the children were, it would be that the parents would get along, even if they are going to get divorced, treat each other as friends, and say, this is the way it's going to be, give and take, but you don't see that very often.
Yeah. So best interest, let's talk about that, because this is a thought that I had. So this goes back to, and I've observed, I should tell the audience, numerous family law cases recently, different parties and all of that. And from what I can tell, and Ken, you can correct me if I'm wrong, we go through this temporary orders thing. So somebody files for divorce, you end up and they do these temporary orders. And as far as I can tell, these are 20 or 30-minute hearings, like a temporary parenting plan.
Yep.
Where someone may end up with very little custody, and they call it temporary until there's a trial, which, it's kind of ridiculous. You have to go to a trial to end a marriage, but they're not that temporary. And the state, through its statutes and Spokane Superior Court, other courts in Spokane, appear to believe that they know what's in the best interest of the kids after a very short 20 or 30-minute hearing.
It's painful. I remember doing one of those hearings as a judge, not as a commissioner. But this couple was fighting over who should get temporary custody pending the divorce proceedings. And I kind of looked at him and said, I'm going to be seeing you for maybe 5 minutes. And I'm supposed to tell you who the better parent is in the best interest of the children. You tell me how I'm going to do that and how fair it is. And this is what you're going to do. You're going to go outside with your lawyers and you're going to figure this out. And you're going to come in and tell me how you have decided to do the temporary parenting plan. They just sat in their seats, looked at the lawyers and said, no, you tell us. Okay, I'll tell you then.
And you, again, going back to your answers earlier, you might have 20 cases. I mean, how much time do you spend? You're reading all these documents and you've got accusations maybe going back and forth. You've got junk flying around. And you spend very little time on each case, I would assume. Maybe if you have 20 in a day or however many it is in a day.
Depends on who the judge is, Eric.
Yeah.
So I found in my short 20-month stint over there in Superior Court that there were very few judges who actually read things before the hearings. They relied on what the lawyers said, whether it was true or not, or whether it was the law or not. I came, though, from a different background at the Court of Appeals. And at the Court of Appeals, they have a little saying that you give every paper the light of day, meaning you look at everything, but you don't just look at it, you read it. So I would take the time to go and read it. So I knew what the case was about. And because I knew what the case was about, I would ask some questions that obviously I had read the record. So I'm asking you a question. And I've had lawyers start yelling at me saying, that's not in the record. I'm looking right at it. It's on my piece of paper. And they started yelling at me at the top of their lungs. And you just kind of look at them and you go, you might want to tone that down because I'm the guy who's deciding your motion. Do you think that's going to help? So they started yelling some more. So that's what you deal with as a judge also.
Yeah. So you've got, attorneys. I know a few attorneys. Are these type A personalities? Are these people that are, again, they're motivated and sometimes by money, perhaps, and family law. But you're dealing with type A personalities. You're dealing with, people that, they graduated law school, they passed the bar, they make good money. It's got to be a little bit difficult.
Well, some are type A personalities, but most are not. I think they're just mean, mean-spirited. Because what you see in the courtroom is how they comport themselves outside the courtroom. Would you want to have a beer with the guy? No. I don't need it. Well, either the beer or the guy. But I guess it's just because of the adversarial process. And why would you want to make things adversarial and be type A about everything and be ornery and be mean just for the sake of being mean when you're supposed to be looking after your soon-to-be ex-spouse? You're just not cutting her loose or him loose, and you're thinking about the kids, but that all takes a back seat. And I've heard trial lawyers say, boy, I came back from trial today and I really made a monkey out of that witness. And so I asked him, well, did you win your case? No, but I really made a monkey out of that witness. That's not right.
That's competitiveness, right? That's some sort of something
Well,
other than my client's best interests.
I guess you could say that, but I played varsity tennis at the U of W in a Power 5 conference. That was way back in my youth. So I guess I was competitive in that, but you can channel your competitiveness into something fruitful. And this type of competitiveness is out of control. Not helpful.
I want to go back to temporary orders. And so you have these temporary orders, and everything I've read said they, if you Google it, temporary orders have a habit of becoming permanent. And many times people will make the argument, let's say these cases go on years, 2-3 years. I mean, most people would say temporary is, a few months or something. But in these family law cases, they can go on for years.
Yes.
Do you think, I don't know, I mean, looking for solutions, and I have a bunch at the end I want to throw by you. I'm a lay person. I don't know if they're feasible or not. But this idea that if they're temporary, why do we call them temporary if they're probably permanent? And if they are probably permanent, shouldn't we be doing more meaningful, or should we be doing more meaningful hearings on this? I mean, it's a 20 or 30-minute hearing. Some judges may read the whole thing, some may read it quickly, some may scan it, but the attorneys and their arguments matter. That's something I picked up on in my research, that they're not that temporary, and they're extremely consequential, very consequential to people.
They are, and there won't even usually be a hearing when a petition is filed. That petition will have the complaint for divorce, you'll have your temporary orders, but that's usually done in ex parte, meaning the other side, of course, isn't even there. And so if you get these orders, it is temporary in the sense that, yes, it's temporary until someone does get a hearing, but nonetheless, that's step one. And you are correct that temporary orders are supposed to be just that, temporary until we can figure this out with testimony, evidence, the stuff that you're really supposed to have at a trial. But it's rather like possession being 99% of the law. If you've got that temporary custody order in your corner, do you think the judge who's finally going to be deciding the final orders is going to vary much from what was said in the temporaries? And no, not usually. Problem is, you can't even appeal the temporary order because it's temporary and it's not a final order. So you're stuck between a rock and a hard spot. Where do you go?
I mean, those are very consequential.
Yes.
If you can't appeal them, and they could last for years, and you could also imagine that the person that won, if there's such thing in family law, that hearing, What motivation do they have to settle or end it before a trial if they got what they wanted that time?
There's little incentive, and you can get temporary orders changed, but it's almost like trying to change a final parenting order after it's already entered and trying to tell the court, well, there's a substantial change in circumstances now. Then you can make a petition to modify it, but you're doing it in the context of the same dissolution proceeding. So it's not very conducive to having a happy split up family. And yes, there are happy split up families. I've seen them, not very often, but they were the ones who were reasonable, even with a bunch of kids. But they decided that for the betterment of the family itself, even though split up, they were going to settle this and not fight.
Right.
I used to do those where they had kids, they figured out the child support, they figured out the custody, they figured out everything. And I was the mediator in those, and I was able to do the papers, file it, usually over there in Davenport, because Lincoln County has mail order divorce. You pay like $35 for the paper handling fee, but you never show up in court because everything is agreed to. I would charge the princely sum of $1,000 for doing that. Can't do it now because as mediators, you can't do the papers because you're not representing either. You can't represent both. And so go get a lawyer. Well, what's the point?
Let me get back. So you can't do that anymore?
No, against the rules of professional conduct now.
When did that change?
Oh, must have been about 10 years ago.
That's interesting. I didn't know that.
Yeah, you could just come in. It's an agreed thing, but apparently dissolution lawyers didn't like that because, you know, you got to do the papers, but I don't want the mediator doing them.
But the mediator is usually an attorney as well.
Sometimes we have, usually our mediators here in Spokane are lawyers, but if you go to the Tri-Cities, well, many of them are not. I thought that very interesting because that's where I did my mediator training, was down in the Tri-Cities, and probably over 50% are not lawyers, which may be a good thing.
So let's get on mediation now. So I'm aware that, you know, you're required to do mediation before trial.
Yep.
But it appears that in most cases, or in the cases at least that I witnessed or read about, mediation's done at the very end, which is odd to me as a layperson, because I'm sure you've heard of sunk cost fallacy, or you may be aware of that. You know, you've already spent all this money, and at the very end, you know, you do this mediation and you're just before trial. I mean, why is it we don't do this at the beginning? Why is it that mandated at the very beginning?
There are some provisions which require you, of course, to go to mediation because that is a requirement before you go to trial. But the problem is in the timing. And as you said, most of the time it's at the end where a lot of the cost, well, maybe 75% of the cost has already been incurred. So I guess the lawyers say, we don't want to mediate until all the information is on the table, meaning you got to do discovery. You got to go through these tests if they are needed or the judge orders them. So you go all the way through. You might as well just go to trial, but yet you go to mediation. Does it work? Sometimes, but when you have court-required mediation, in practicality, that means if one person shows up, wants to mediate, the other person doesn't want to mediate at all, but has to show up, he or she shows up, says, okay, I'm here for the mediation, not doing it because I don't want to agree to anything. That's good enough to satisfy the mediation requirement.
You know, I've heard in California, for instance, there's some sort of counseling or something early on. Trying to think of things that Washington State could do. And I understand there are far few, I may be wrong on this. This is, you know, personal references telling me you don't see as many trials in divorce court. Which in my mind, as a layperson, again, it seems like a trial would be the worst case scenario. It's the most expensive, the most destructive possible outcome. Even if you win, you don't win. You know, it's a civil war, and you know, you just kind of survive. But they do some sort of counseling at the beginning. Is there something, you know, because I don't feel like some people that I've talked to have any idea really of how expensive going through, you know, full discovery, which I want to ask you about in a second.
Hmm.
You know, I don't know.
Well, counseling is rather like trying to quit smoking. If you really want to quit smoking, you can quit.
Yeah.
Been there, done that. I've gone through the portions where I didn't want to smoke, which meant I didn't buy my cigarettes. I just bummed them off my friends. So that meant I was quitting smoking. But I finally quit because I wanted to. Counseling is not going to work if you don't really want to make it work. You can go through all the motions, but it will get you nowhere. But at least it's a start. You can at least try. And I kind of tried that in the criminal law arena when I was on the bench. When you see somebody at trial in a criminal case, we're way too late to be helping that person get any better. You got to start way at the beginning, meaning grade school. Before that, you know, learning values. And that went over like the proverbial lead balloon too, because it's an industry. It is an industry. If you do away with the criminal law infrastructure, oh, there's a lot of people out of work. And so there was, I wouldn't call it blowback because it wasn't. It was just not heard. And they thought I was full of bullshit. So
This is good stuff. So let me get this straight. So, well, let me get to how judges become judges. I mean, we heard your story. In Washington, they're elected, but some are appointed. Can you clarify who's elected and who's appointed?
if a judge gives it up by retirement, voluntarily quitting, health problems, the governor gets to appoint. So if it's a Democratic governor, most likely you'll have a Democratic appointee. Not always, but that's how an appointment happens. Sometimes judges, perhaps there is a Republican governor and the judges, although nonpartisan, he or she may be a Democrat. I'm not going to give that Republican governor a chance to appoint someone in my spot, so I'm going to hold on until general election. And that happens. Then you go to a general election. If you are appointed, say you're appointed in January of 2024, you don't get to have carte blanche until the next time all Superior Court judges run, for instance. You have to run in that general election of that year. So that is a consideration for appointment. That's basically number one question. Are you ready to run? Because I was appointed a commissioner at the Court of Appeals, appointed Superior Court judge, and appointed a Court of Appeals judge. So I've gone through that. And yes, I did have to run a contested election once. Most
So-
appointed, I think.
So even. Wow, so even in Superior Court, local courts,
Mhm.
politics are part of it.
They are, but I was probably, I know I'm at least one exception, because I was not politically active. And I became a Superior Court judge. And it was a very unusual process, because I went through 2 other times trying to get appointed. And I knew the governor's counsel. I guess he took a liking to me, says, you got no chance. So he'd tell me that. They don't usually tell you that. They probably shine you on a little bit. Because then, well, how about this time? You don't stand a chance. Okay. The third time is, why don't you just go try again? And I was getting my ID at the for the Court of Appeals at the Public Safety Building. And this lady says to me, you look like a judge to me. Why don't you call my husband? Okay, I'll do that. So I talked to her husband that afternoon. He said, I like the way you lose. Those are my 2 prior appointments. I didn't raise a squawk. I like the way you lose. You're next. And that's how
Wow.
I became a Superior Court judge.
This is all good stuff. Couple
It's
questions to
very
follow up.
strange.
Yeah, this is all good stuff. I really appreciate the candor. So you were appointed commissioner,
Yep,
all right, but in
that's a
Superior,
non-elected pot.
all right, but in Superior Court, who hires the commissioners?
The judges.
The judges hire the commissioners.
Yeah.
Okay. And would you say a high percentage of these commissioners and all judicial officers in Superior Court, were a lot of them attorneys in family law, divorce attorneys before this?
I'd say more general practitioners. And then it became ex-prosecutors. Very rarely will a public defender be appointed a judge.
Yeah.
Some civil law attorneys, and I was a civil law attorney, but like I said, I've had one trial since 1975 when I graduated from law school. So what in the world am I doing being a trial court judge? Well, believe it or not being a trial lawyer helped me, because I knew the games they were playing that I could see as an appellate lawyer and as a researcher doing motions in front of judges, not trials, but I could see the games they were playing and whether I would let them get away with it or not. And the
That's a
answer
good
was
point.
no. The answer was no. I probably would have let them get away with it if I were a trial lawyer. Because
That's
I
a good
probably
point.
pulled those same tricks myself. And that's one of the reasons I didn't do trial law, because you're not there to pull tricks on people and make it into a sideshow.
Good stuff. So you had to run for general, you had to run in an election to get
I did.
reelected.
I like the unopposed elections the best.
Yeah, I bet.
I had about 3 of those. That was good, but I did have to run as a Court of Appeals judge.
And so when you're running as a court, I mean, is that the 5th congressional district, like as we know it, or is it a different district or?
Well, I was in Division 3, which is everything east of the Cascades to the Washington, Idaho border, Washington, Oregon, Washington, Canada. So it's a huge area. And in my particular district, I had 9 counties to run in. And they ranged from Spokane, Pend Oreille, Ferry, Stevens, Okanagan. And I guess I guess one of the things that was interesting to me was that a commissioner of the Superior Court in Okanagan called my fellow judicial officer at the Court of Appeals and said, "Hey, I voted for that Egyptian guy who's already on the court." And I'm going, well, if you're going to get that, at least get it right. I'm a Japanese guy. I'm not Egyptian, but it was very telling in that they knew that I wasn't a white guy.
Yeah.
And that was very interesting because I got my butt kicked in all the outlying small counties. In fact, I was down 6,000 votes on the very first night.
Do you mind sharing who you were running against? You don't have to.
Brian O'Brien,
Don't know.
you know, a fine Irish lad. The
Yeah.
problem is he ran on being Irish Catholic. Well, he's Canadian LDS, but those signs were up saying that kind of stuff
Okay.
in
Do
the
you have a
county.
4-leaf clover in the bottom or nothing?
Yeah, but my signs were green. I preempted him. So
So
they were faked out.
So when you're running for, I mean, I've always, me personally, is it better to appoint judges? Is it better to elect them? Pros and cons to each, and Peg doesn't take any stance on that. But I am concerned about, where does the money come from? We've done
Me
forums on
too.
money in politics a number of times. I happen to know, I mean, there are definitely attorneys in Spokane who give to campaigns of people who,
Yes.
they're in front of that judge. And I don't know why there's not more scrutiny on that. I did witness a case where one particular judge felt the need, and I appreciated that she said that one particular attorney had offered to be her campaign manager, but yet is hearing cases in front of that person. I mean, does this stuff happen? I mean,
It does happen. And I guess Texas is where the big money comes in for a chosen one. And yet those law firms are appearing in front of that person. And campaigns are very expensive. Mine was in 2004, so that's a good 18 years ago. And I had no television ads. And we only had 6 weeks of campaigning because that was back in the day when there was only 2 people running. The primary was the general. So whoever won the
before the
primary,
top 2 primary.
yeah. And so in that 6 weeks, the total was over $60,000 for campaigning. Most of
And
the
that,
time, judges lend money to their own campaigns because no one really wants to give to judge races, because you don't really know anything about a judge. You can't talk about it. You can't talk about topics, just that, oh, I'm a really good guy and perhaps you should vote for me, which isn't a very good endorsement even by yourself. But it is expensive. I was very fortunate in that I had a campaign treasurer who liked me for some reason. I didn't really know him, but he wanted to help. And I think I ended up with 1/10 of that amount that I had to pay. He was able to get contributions for the rest.
that's good.
And I was a very lucky person. I've been told many times by other judges that happened.
I mean, and I'm conflicted. What are the qualifications to be, like, I don't have a JD. Could I be a judge? Could I run for office, or are there certain?
Well, you used to be able to be a justice of the peace in the outlying counties. You didn't have to have a law degree. But
Really?
yes, that was done away with. To be on the Court of Appeals, you have to be a lawyer for 5 years. I think for Superior Court, it's 3 years. But you don't have to have any qualifications. Just be a lawyer, living and breathing, and that's about it.
Anybody on Broadway Avenue or a 3-block radius of that?
Well, that's about it. One fellow on the Supreme Court decided he was going to run against the sitting justice of the Supreme Court of Washington. He spent $1,000 for the filing fee, sat at home, did nothing, voted on election day, and lo and behold, he got elected. He beat
won.
the other guy. Amazing. He's
There's
still
got to
there.
be a better way.
Yes.
Not that
there's
I
a-
don't think common folk or laypersons couldn't sit in front of a, I'm sure Superior Court and hear a family law case but Washington State Supreme Court, you're dealing with case law and all this stuff. That guy won and he's making decisions.
Yes, he is. He's still there. And I think he's one of the oldest members of the court. He made himself into a good judge, but he was just a regular old general practice guy until he decided to run. And one of my fraternity brothers is actually a Court of Appeals judge in California. And the way they do it in California is you are appointed. And then California gives you a couple years, see how you do. Then there's an election, but there is not an election with another person running against you. It's whether to retain you or kick you out.
And how does the public honestly know? I mean, I filled out ballots with judges before, I became familiar with this topic. I don't know who I was voting for.
Well, that's one of the problems with the Code of Judicial Conduct is you are very restricted on what you can talk about. It's a shot in the dark. And I get calls all the time around election time, and I know who's going to call. All right, who should I vote for judge? Because I have no idea who these people are. And you don't, because you can't talk about any topics, because then you're tipping off how you're going to rule is the thought.
Got a few more minutes before I'll turn it over. We'll start asking some audience questions. It's really
Okay.
fascinating stuff. How do people afford this? Like, I saw this one case where, you have these temporary orders that kind of lock up all the community assets or even separate assets, and they say it's locked up. So how do people pay attorneys? I mean, what are people supposed to do? One person told me you just have to borrow the money.
Some do that. Some have family help out. Like I said, I do criminal law appeals and things called personal restraint petitions, which are the second bite of the apple for someone who's been convicted in the Superior Court and then whose conviction got affirmed all the way up on direct appeal. Family gets to pay for that, because when you're doing license plates and cutting dies for about $1 a day, it isn't good. They're not ever going to be able to afford it. So that's how the lawyers get paid. And on the west side, lawyers actually take liens on your house.
Oh my gosh.
Yeah, if you stiff them, you have just lost your house. I don't know how they can live with themselves, but they do that.
So attorneys, presumably, and you could correct me if I'm wrong on any of this, write the codes of professional conduct. Attorneys, for the most part, write the statutes. I mean, most legislators, I think, or a high percentage of them are attorneys. Judicial officers were attorneys themselves. We're putting a lot of confidence and a lot of power into the hands of the people that financially benefited the most from these cases?
Well, it's the
Correct
police
me if I'm wrong,
policing-
state it differently, however you want to say it.
No, it's the police policing themselves.
Yeah.
Actually, the rules of professional conduct and the code of judicial conduct, the Supreme Court has control over that. And of course, the 9 members of the Supreme Court are all lawyers. They're called judicial status, so you can't actively practice, but yes, they are lawyers. And I think nowadays there are less lawyers being legislators, but nonetheless, who do you think writes up the statutes? It's not them. They have people who do that, and they are lawyers. And then you have, say, complaints against a judge. Who does that go to? Well, it goes to the Judicial Conduct Commission. And who are they? Lawyers. Or you have a complaint against a lawyer. Where does that bar complaint go? Well, to the Washington State Bar Association. And who investigates that? Not staff, lawyers. So,
And how about the
You
local
bet.
rules, like the local rules for, say, Spokane Superior Court?
the judges do have some say on that, but there's a committee of lawyers who draft those.
It's completely controlled by lawyers, and in Spokane, and I know this, and you mentioned it earlier, a high percentage of the attorneys here in Spokane all went to the same law school.
Yes,
If
they
you
did.
Googled, if you just, anybody, feel free to Google, divorce attorney Spokane, whatever. You go through the first 2 pages, I would be shocked if you found more than 1 or 2 that did not go to Gonzaga.
That's probably correct.
And presumably many of them know each other, from the paralegals, judicial assistants, judges, probably went to school with each other. It's just, it seems problematic from a layperson's perspective, or at least it deserves a little bit of scrutiny from, I don't know, an oversight perspective.
It's kind of like French aristocracy, isn't it?
Yeah.
Too much inbreeding. And you have problems with that.
Right.
You don't have a different perspective on either the law or how you administer the law, because you did go to a certain law school which has a certain way of teaching things.
An echo chamber.
Well, Gonzaga
Well-
used to teach you with rote memory.
With what?
You can rote memory. You can cite the cases. You can even tell what the citation is. So I would ask my buddies who went to Gonzaga, okay, you know that. What did that stand for? I don't know, but I can tell you the case.
Hmm.
See, that's not very analytical.
Right.
But I can spout it out for you right on the bar exam.
Right.
Not anymore. It's multiple guess. It really
I'm
is.
gonna start getting to some audience questions, and again, feel free, anybody, to type in the Q&A feature on Zoom. I'm gonna get to as many as I can, and then I have some final ones before we end as well, Ken. I really appreciate your time.
Okay.
How do we put the family back in family law?
Get rid of the lawyers. How's that? Get rid of the judges.
And you're an attorney.
Yeah, I mean, it is an area of law it gives you enough conflict. You don't need to have persons representing you and your interest engaging in more conflict. And, you're going to
Force
talk about,
multiplier almost, right?
well, you're going to talk about mediation. When I do mediation in family law, I kick the lawyers out. You and your as soon to be ex-spouse are going to be in the same room, not in separate rooms. You got something to say to each other, you are going to say it to his or her face. And it works a lot better to in my mediations, it's always the lawyer who messes it up. Well, a judge wouldn't do that, so why would you, cave in on that? Well, the whole idea of mediation is that you, as a party, have a say in how things are going to come out. If you want to do what a judge is going to do, or what you think the judge is going to do, then go to court. Don't waste your time on mediation. So I don't want lawyers there at a mediation in family law. I kick them out. The parties are going to talk. And I get a heck of a lot farther that way. And people can actually be reasonable when they're stuck in the same room and they have to talk to each other. It works.
That's a different philosophy, and
A lot different from the other mediators. They always tell you what a judge is going to do. That's not my role, to me, as a mediator, to do that.
right.
I
Because
can tell you what a judge is going to do because I was one. But why would you want to hear that? It doesn't matter.
well, it just seems, again, from afar, that everything about the process discourages pragmatism and encourages conflict.
Yep, I agree.
Here's another one. What do you think of the fairness of one party can afford a lawyer and the other party cannot? Then the first party lawyer gets the party without the lawyer to pay for his fees plus most of the assets and custody of children.
That does
Basically
happen.
getting to what if, one person can't afford, one can. It gets to that, the haves and the have-nots. You have to borrow. You mentioned you might have to borrow from friends or family, but your money's kind of locked up.
It is.
Obviously, it's the same in criminal law. People with more money tend to have better outcomes, I would assume.
Well, that's the old saw you hear on TV, and it's actually true. The best justice money can buy.
Yeah.
I mean, a lot of my clients didn't like their public defenders. Well, they're good lawyers, but they're overworked. And they're doing it for a fraction of what I'll call paid criminal lawyers get. So same thing with family law. If you can afford a so-called hotshot attorney that's going to charge you $400 an hour and 60 grand a month, if you can afford it, you probably stand a pretty good chance of winning because they'll churn a case to death.
It's just sounds like, if I'm paraphrasing, it's just an inherent inequity. There's not any easy answers to. Is that paraphrasing?
It's a bad system. And to get a better system, you have to get away from the adversarial business. And it's so ingrained in what not only the courts do, because that's where you resolve these conflicts, but it also guides what lawyers do. And it may not always be in the best interest of the client. It doesn't make sense to charge $10,000 for a contempt motion and you might lose it. It makes no sense, but they do it anyway because you're paying.
They get paid either way.
Yep.
It's not paid for performance or anything like that.
The only ones who win in a divorce case are the lawyers. It isn't the parties.
Here's another question. It also seems that today's courts seem to favor women in family law. And I'm a woman and I've seen several men lose everything. There's probably, Ken, you've heard that there's certainly that stereotype about men in family law. I guess I came looking at different states. What did strike me was that Washington doesn't seem to be a state that assumes 50% custody, for instance.
Yep,
It's based on best interest of the kids, whatever that means.
Yep. I think men sometimes get a raw deal. Used to be much more so when I was over there in Superior Court back in 96 and 97. You saw that. Not so much now. Supposedly, the judges are listening and don't lump you into the bad guy category. So I have seen men get the custody and sometimes even get support from the ex-wife. Of course, it may be a high-tech guru, and that's where the money comes in, but
I'm
I don't
wondering if
think
it's,
it's bad.
I'm wondering if it's more about do you think there's any discrimination against the working spouse? Is it less about gender? Is it more about who makes the money?
I think the one who makes more money tends to win more. And if there is a question about custody, the judge seems to almost invariably ask, well, if you're working, who's going to take care of the kids?
Right.
And that is not good if you are the breadwinner. And what happens when both are working? Well, that's when you start throwing the mud.
Yeah.
Because it's a wash as far as finances go. And I've seen that happen too. Actually, a high-tech guy, he's in IT, and the spouse is an acupuncturist, making pretty good money. So what do? Well, you throw mud. Well, he's always working, and he's got odd hours because he has to work at home, and he's not taking care of the kids. Yeah, and he got less custody than when they started because of that.
Seems like it, to a degree, it may discourage working, or at least view that as less admirable or something. I don't know what the words are. It's another question. Go ahead, Ken.
Yeah. No, well, you have judges and guardians ad litem not doing what their charge is, which is to be neutral and advise, but to infuse their own values into how you parent. And if it's not what the judge or the GAL prefers, I think that's not going to count very well for you.
Real quick, just explain to the audience what a guardian ad litem is. I don't think we touched on that.
Guardian ad litems are court-appointed advocates for children. And they are not expert witnesses, although I think they sometimes think they are. They are to inform the court as to what best alternatives are for custody. And, well, they're getting paid for it. And I've actually had a Superior Court judge on appeal say, I never took much stock in guardians ad litem, so I'm not even going to listen to him.
Oh, wow.
He's the only one, though, that's ever said that. He's no longer on the bench. He retired. And so,
well, if you're spending money and the judge isn't going to listen, that doesn't mean that's not very good.
Well, guardians ad litem are paid by the county in some cases, and that's for folks who really can't afford it. But I've also seen, this is the highest I've ever seen a guardian ad litem charge, but she charged $70,000 in a guardian ad litem case. It was unbelievable. Never seen a bill like that. And she got
70
it
grand.
all. She got it all.
Here's another question. Most of the county commissioners in Spokane are women. And again, it goes back to the perception that women are favored. Do you think that's a problem that we have more women than men, or is it, just kind of a wash and it's more about mentality? Or
like county commissioners, as in commissioners of the Superior Court?
Yeah, I think that's what's meant by it.
Most of them are indeed women. And there are a couple that I know who tend to favor what the woman says in the hearings. Those will usually get appealed one way or another when the time comes. But I think the commissioners actually do try to do the right thing. And I think I said that one time when I was given a talk at the Seattle University Law School. And I said, well, as a judge, I try to do the right thing. And somebody raised their hand and says, well, what made you boss of the world? And what you think is right is what's right for everybody. And so I had to think of something to say. I told him it's because I have my ethics, I have my views, I have my morals, and you cannot divorce that from any decision you make, but you temper it with what the facts are, what the law supposedly is, and you all factor in that, and you can do what you think is right, and you have to live with yourself. If you can't live with yourself, you done wrong.
Do you think that most judges more or less think that way?
No. Now, I've seen way too often lately, a judge will pretty much come up with reasons for a decision. But what it's really rooted in is I've seen this before. You're no different, and I'm going to do the same thing that I did before. In other words, you are not an individual. You are, I've seen you before. Not
A
you
category.
personally.
And I've
Yeah.
actually seen attorneys play on that a little bit.
Oh, that's like, well, the judge would do this, and the judge did that in that case. Well, I wasn't that judge, was I? You got a new one now, so I'll make my own decision on that.
Here's an interesting question. If judges go into debt to run for election, isn't a campaign contribution effectively the same as paying a judge? I hadn't thought about that, but
Some folk think that, and actually, judges can endorse other judges or to be judges in judicial races. And there were a couple of judges here in Division 3 at the Court of Appeals who endorsed somebody running for Superior Court in another county. And one of the big wigs in their bar associations thought that was the worst thing in the world for these judges to be endorsing another judge or judge to be when they're going to be appearing in front of them. And it's the same thing when you're making contributions. You know, your treasurer takes care of the contributions, but you, as the one who's getting the contributions, knows darn well who's given it to you. And occasionally, I never had to do it because no one contributed any huge amount. It was just a bunch of folks and it was across the board. But if someone's contributing a bunch, you might want to recuse yourself from that case and not do it. I mean, voluntarily. There's nothing in the Code of Judicial Conduct that prevents you from hearing the case. It's whether you feel you can do it without breaching the appearance of fairness, which is all you need to boot a judge off. Not that he or she is biased, but the appearance of fairness has to be there too.
I mean, I would think if I was a judicial officer, I just want no part of it. But does that always happen?
Surprised, Eric, you'd be surprised how many folks say, I don't care, I'm going to hear it anyway. I've had it happen at the Court of Appeals. Don't you think you ought to, get rid of yourself on that? No, not going to. There's no affidavits at the Court of Appeals. Those are affidavits of prejudice. And no one's asked for me to boot myself off, so I'm not doing it.
And by affidavit, you mean where one of the parties can get rid of a judge because they feel prejudiced. And in the Court of Appeals, there's none of that.
Nope, can't get rid of any Court of Appeals judge that way.
They just have to willingly out of their
Yeah,
own.
that doesn't happen very often. I
Yeah.
kicked myself off of all my old law firm's cases for about 5 years. And usually after 5 years, it's okay. but I still didn't do them. Yeah, it just doesn't look right.
And the parties probably don't. I mean, even if you explain the decision, I would imagine the parties will, in the back of their head, always have that in their minds, you know?
It is in the back of their minds, and they shouldn't have to be thinking about those types of things. If you're in the feds and you're a judge and you own stock, say one share in Amazon,
Mhm.
you can't hear any Amazon cases, period.
Yeah.
You are automatically out. They're much more stringent than the state.
Here's one. How do you choose an attorney? And this is one I'm sure a lot of people come up with. How do you choose an attorney or know when to fire one?
How you choose an attorney, you can always look it up on the internet, because if it's on the internet, it has to be true. So if a guy's got 5 stars on Avvo, well, that lawyer must be great. Not so, because you get your friends to put in 5-star ratings, and that's how you get your 10s and your 5 stars. The best way is word of mouth. Ask, because the lay people who have dealt with attorneys know who's a crook and those who aren't, and who did a good job and who didn't, who gouged you, who didn't. And that's probably the best way to do it.
Yeah, I'd say that's probably how most people come to it. Yeah, but obviously reviewing Google reviews are probably going to be a little slanted.
It's a start, and firing them, if you feel that lawyer is not listening to you, taking input from you, you got to have a talk with that lawyer and say, look, I hired you, you're working for me. Why aren't you? And if not, you're out.
This goes back to, like, I talked to a person just a few days ago and it was amazing. Her and her ex agreed on everything, absolutely everything. But the divorce still cost her $20,000. And then how did it still cost $20,000 if you guys agreed on everything? And the answer was this discovery process. I mean, can you talk a little bit on discovery, or particularly in cases where there's not a lot of conflict at the start, there's mostly agreement. Talk about the expense of discovery.
Discovery is expensive. It's time consuming, as you do these things called interrogatories, the written questions. And sometimes they can be 50 pages long, asking for financial documents for the last 20 years. That gets a little burdensome. It also costs time and money for you, because it's not your lawyer doing those answers, it's you. Also, discovery entails depositions. Depositions are not cheap. The court reporters are very expensive, and the lawyers are charging you their hourly rate for every minute you are in there. And so I used to work for an insurance defense firm that did a lot of it. Pretty much you knew the case was going to settle, but everybody did their discovery all that time before, and they would settle on the courthouse steps, because all the costs, it's not so much in the trial, it's in the discovery and pre-trial workup. So you do that first, then you settle. And to me, if parties are willing to settle, there's no dispute, unless someone thinks someone's hiding something. There's no reason for discovery. If you agree, what do you want to discover? I don't get it. And it shouldn't cost 20,000. They came to me 10 years ago, it would cost them 1,000. So there you go.
I know of this one case where this gentleman was served with 200 interrogatories, and some of these questions were 10-part questions. And so, it was thousands of pages, and then the attorneys had to go through those thousands of pages. And so you can see how it gets expensive.
Well, that's when you're a lawyer, you got to go tell your lawyer, hey, this is burdensome. They're asking for stuff that means nothing. It does not lead to discoverable evidence. So your lawyer goes and objects and says, this is burdensome. It won't lead to any evidence that's usable. So what's that going to do? They have to confer about discovery. And then the other's like, well, we didn't get anything settled, so now we got to go to court. And I'm going to move for sanctions, and I'm going to move to compel discovery. So $5,000 later on each side, you're nowhere. And you haven't done anything.
Another question, state Supreme Court judges are becoming very important for states' environmental law, conservative versus progressive state priorities. Example, Wisconsin Supreme Court judge election, a lot of side money poured in. I'm not exactly sure what I think I get the point. Any comments on that?
Probably not quite so much of that here in the Washington Supreme Court, because I can tell you, as Supreme Court justices, you are not so much a judge as you are a politician. So yes, you are beholden to the special interest groups and even PACs that go and contribute money to you. But I think over here we're rather egalitarian, and it's not so much environmentalists. And there are also criminal law activists on both sides, lighten up or make it worse. And with this particular court, I don't think the justices, you can predict what they're going to do, particularly by contributions, because I can't even predict what they're going to do the next day from what they did the day before. They seem to be changing their minds. And a good example of that is juveniles and youth doing crimes. You now can consider their youthfulness. Now, it started about 5 years ago. And then earlier last year and this year, the Supreme Court, same people, have backed off almost completely from that. And there's no rhyme or reason for them to do that. It's odd.
Here's one. How can we promote more mediation and conflict resolution?
Get rid of the lawyers. That would be a very good thing. Like I said, lawyers to me are the biggest impediment to me when I do mediations. And I'm talking about not only family law, but all mediations. I had one case mediated where the one side wanted just an apology, and restitution of about $50,000. The other side absolutely refused, and it cost us 7 figures.
7 figures.
Yep. Could have been done away with an apology and 50 grand.
No pragmatism in that, is there?
No, but when you're making $500 an hour representing somebody, it does not behoove you to settle, and he did not.
Here's another one. How can we decrease plea bargaining in criminal cases which adversely affects persons of color? That's more of a criminal question, but you've had it, so.
Well, it actually affects white guys too.
Mhm.
I mean, when you have exceptional sentences, for instance, white folk get hammered just as much as black folk. The ones who really get hammered are natives. Native Americans, you are screwed. Latino, not good. So how do you get rid of the backlog of criminal cases, because there is, you plea bargain. Are there fair plea bargains? No. I'll give you a for instance. I'm helping this guy who has a 184-year sentence. He was 25. Needless to say, he's going to be real old when he gets out. He did not pull the trigger. The guy did not die. In fact, he's fully recovered, the victim. The guy who took the plea bargain, the shooter, got 10 years. No firearm enhancement, despite the fact that he shot him obviously with a handgun. One gets 10 years in the plea bargain, the other gets 184 years. Why? Because he didn't take the plea bargain. He did not want to testify against his best friend. His best friend, however, didn't have any such qualms whatsoever. You do need plea bargains, but they're sometimes not the best bargain in the world. I turned down a plea bargain once as a Superior Court judge because this lady actually got shot. And from a first-degree assault while armed with a deadly weapon, the state plea bargained to a fourth-degree assault, which is a misdemeanor. I said, I just hauled the lawyers into my chambers. That's judge talk for office. And said, I'm not doing it. Go find some other idiot who's going to sign off on this. The defense lawyer to this day, I see him at the golf course. He barely talks to me because he did not like it that I turned down his bogus plea bargain. I didn't think much of it. And I had the power to turn those down.
I've watched enough Law and Order episodes to know it's really selective and who gets the deal and who doesn't, you know.
Well, you know, putting people in jail, you need
Yeah.
to put some people in jail. But throwing everybody in jail is probably not the best thing in the world because you could send a guy to prison. 5 years ago, it was 60 grand a year for each of those guys. That's how much it costs to keep them there.
Yeah.
That's a lot of money that could be used elsewhere.
Yeah. Has the policy of not punishing perjury, false statements, and other dishonesty created moral hazard to the point to where lying is almost encouraged? You know, so as far as I can tell, I've done I can't find a lot of instances online of attorneys being actually prosecuted for perjury. I bet it happens.
Don't see it very often though, Eric.
Yeah. They have the CR-11. I think you're familiar with that, where they're sort of sanctioned maybe, but I don't know. Is there a moral hazard or is there so much junk and lying and dishonesty and misrepresentation flying around that we just let it go?
Unfortunately, I think a lot of it does get let go in the sense that there is no penalty for it, like perjury charges, because that is a criminal offense. And I've seen a bunch of cases in those 20 years as a judge, and you know darn well somebody's lying their teeth off. And it could be a party, it could be a witness, it could be a lawyer. Yeah, lawyers are included too. But does the state want to do something about it? And that is not often. It has to be so egregious on a case, it has to be huge.
Yeah, and again, I've seen family law attorneys endorsing, giving money to district attorneys who would be the ones to file a perjury. So it just doesn't seem very likely.
No, and I think that's probably one of the bad things about having an electoral system for judges and, you know, persons like prosecutors and even, you know, the public defender's not voted on by the people, but the prosecutor is. And well, that money's got to come from somewhere. So who's currying favor and who's getting it? And it could be the big law firms. Hopefully not, but I'm not so naive to think it doesn't happen.
Gosh, I just have a couple more. We're right at, this has been fascinating. But we are right at our typical closing time. I'm gonna try to get a couple off really quick. I had so many ideas I wanted to float by you as possible. We might have to do a follow-up at some point. But how about, do the guardian ad litem or let's say expert witnesses but you said guardians are not technically expert witnesses.
Yep, they're not supposed to be, and there's even cases that say that.
Okay, do the guardians play favorites for repeat business? Let's say you're like, I don't know. Let's say you're pro se, meaning you're representing yourself, and then you have a guardian. You know, that pro se person can't give you repeat business. But the attorney on the other side, potentially, I mean, it just seems like there's inherent conflicts of interest there.
Yes, I've been told that happens and that they go back to
Yeah.
certain GALs who have made favorable recommendations for their client. Because there's a lot of guardians ad litem out there, and it's a crapshoot if someone like the court appoints someone and you've never heard of that person. In fact, I've been in that court system for quite a while, and there's guardians ad litem I've never heard of before, but the family law lawyers know them.
Right. Well, I hate to do this because we have more questions, and I apologize to the audience members that didn't get a question. We may do a follow-up at some point on this, as we've done on other issues. I'll leave it with this just comment from an anonymous attendee. Ken Cotto, why did you retire as judge? You have such common sense and compassion in your answers. Spokane needs more like you. I think you touched on this earlier, but we'll leave it at that.
I can tell you was the last straw that broke the camel's back.
Tell me.
When I was at the Court of Appeals, I was just sitting in my desk, and my fellow judge came up to me and said, you know, these cases that we do, they're just numbers to me. They're not real people. And what we do here are merely academic and intellectual exercises. I don't give a crap what happens to these people. I just kind of looked at him and said,
And that's,
are you kidding me? And he was not kidding. So that was about the straw that broke the camel's back, and said, if I have to work with that type of mentality, I'm not doing it, because it takes two to decide a case at the Court of Appeals. And I was that lone voice in the wilderness, and no one was listening. So I decided I'll bail and try to help out people back as being a lawyer.
what an amazing statement for somebody to make. And
He was proud of it, Eric.
yeah,
Pissed me off, to tell you the truth.
maybe he should have retired and not you. But I'm glad you're helping people in appeals court, which is a check on some of the things that happen in Superior Court. But Mr. Cotto, Judge Cotto, really appreciate your time today.
Sure.
I'm going to do my brief little spiel here, but anytime Peg would welcome you back. There's so many more questions, but really
Glad to
happy for your candor. You seem to have sensibilities that are in
faked you
line.
out.
What'd you say?
Did I fake you out?
You seem to have sensibilities that are similar to our membership. So I appreciate your time. On behalf of the PEG board and membership, we wish to extend our gratitude to Judge Cotto for his willingness to spend the evening with us discussing family law, which impacts so many in our community. Thank you also to the audience who are so much a part of the work we do. A video of this evening's forum will be posted on PEG's website within a couple of weeks. We hope you will join us in April for a forum on refugees in Spokane. We're looking forward to that. Details will be distributed within a week or two. Everybody have a great night.
Thank you.
Thanks, Ken.